Welcome to our justice. Some men lose everything slowly, piece by piece, like paper tearing along a fault line. Others lose it all at once in a single moment they never saw coming. I fell somewhere in between. I lost my marriage quietly, over months of cold silences and locked phone screens. But I almost lost my son in a single morning, in a courtroom under fluorescent lights, with a judge I'd never met deciding the rest of my life in the space of a few hours. This is the story of how I nearly handed my child to a woman who had already decided he was just leverage, and how, in the end, it was his voice, not mine, that saved us both. My name is Daniel Reeves. I'm 41 years old. I work in logistics management for a regional freight company. I'm not rich. I'm not particularly interesting. I'm a guy who coaches youth soccer on weekends, who knows every teacher at his son's school by name, who keeps a spare inhaler in his car because his kid has asthma and you never know. My son is named Owen. He was 10 years old when he walked into a family courtroom and changed both of our lives. I want to tell you everything from the beginning because context matters, and because I found that when people hear the ending first, they forget that there was a long, grinding middle where I genuinely didn't know if I was going to make it through. Yvonne and I met when we were both 26. She was working as a dental hygienist. I was 3 years into my logistics job and just starting to feel like I had some footing in the world. We met at a mutual friend's birthday dinner, and I thought she was the most direct, no-nonsense woman I'd ever encountered. She said exactly what she thought. She didn't play games. At 26, I thought that was rare. We dated for 2 years, got engaged, married when we were 29. Owen came 14 months later. For the first 5 years of our marriage, things were genuinely good. Not perfect, but real. We argued about money sometimes. She wanted to upgrade our house before I thought we were ready. I was more conservative with savings. These were normal disagreements. The shift came gradually, somewhere around year 6. Yvonne had started a new job at a high-end dental practice in the city, which meant longer hours and a new social circle. Colleagues who took winter trips to Scottsdale and spent their Fridays at rooftop bars. I don't say this with resentment. People grow, social environments change you, but she started coming home later, phone face down on the counter. Less interest in the Saturday routines we built, soccer practice, lunch out, a movie if Owen picked it. I noticed. I didn't say much at first. I told myself I was imagining things, that I was tired, that working 50-hour weeks while managing a household was making me paranoid. Then I stopped telling myself that. I found the charge on our joint account, a hotel downtown, a Tuesday night for 2. She'd told me she was at a late team meeting. I didn't confront her immediately. I took a photo of the bank statement on my phone and said nothing. That was the moment I changed, not into someone angry, into someone careful. I started paying attention differently. I noticed when she came home how she smelled, what excuses she gave. I'm not proud of the monitoring instinct, but I want you to understand I wasn't gathering evidence for a divorce case yet. I was still trying to figure out if what I suspected was actually true. A part of me desperately hoped I was wrong. I wasn't wrong. 3 weeks after the hotel charge, I found text messages on her iPad. She'd forgotten that her phone was synced to it. I didn't read them all. I read enough. The man's name was Trevor. He was a patient coordinator at the practice. The messages made clear this had been going on for several months. I closed the iPad. I went to the bathroom. I sat on the floor for about 10 minutes. Then I got up, washed my face, and went to Coach Owen's soccer practice. We separated 4 months later. I'd spent those 4 months consulting with an attorney, organizing my finances, and, quietly, documenting what I'd seen. Not because I was planning to destroy Yvonne, because something my attorney told me early on stayed with me. She said, in a custody dispute, the person who walks in prepared almost always does better than the person who walks in emotional. 6. I wanted to be prepared. Owen was 8 at the time of our separation. He knew something was wrong. Kids always do, but we'd agreed to tell him together, calmly, that Mom and Dad were going to live in different houses, but that both of us loved him completely. That conversation was one of the hardest things I've ever done. To her credit, Yvonne held it together for Owen in that moment. Whatever else happened between us, she loved our son. I've never doubted that. What I came to doubt was her judgment, and her honesty, and eventually her priorities. The first year of separation was painful but manageable. We had an informal custody arrangement. Owen split his time roughly equally, and for the most part, the handoffs were civil. My attorney had filed the initial paperwork. Yvonne had her attorney. Formal custody proceedings were scheduled but kept getting pushed because both sides were technically cooperating. Then, things changed. Yvonne's relationship with Trevor had ended. I learned this through a mutual friend who mentioned it casually, not knowing the full history, and around the same time she hired a new attorney, one who, I would come to understand, had a very different approach than her first one. Within 6 weeks of the new attorney coming on board, I received a motion. It accused me of being emotionally unstable, financially irresponsible, and, the one that hit me like cold water, neglectful of Owen's medical needs. Owen has asthma, mild to moderate, well controlled with medication. I have been the primary manager of his health appointments since he was diagnosed at age 5. I know his pulmonologist by name. I have the app on my phone that tracks his peak flow readings. I have never, not once, missed a treatment or let his prescription lapse. The motion suggested I had on multiple occasions failed to administer his inhaler when needed, causing him distress. It was completely false, but it was in a legal document with her signature and her attorney's signature, and it was now part of the official record. I remember sitting in my attorney's office after reading that motion. Her name was Patricia. She was calm, measured, a family law specialist with 20 years of experience. She'd seen motions like this before. They're setting a narrative, she told me. This isn't about Owen's asthma. It's about establishing you as an unfit father before we get to the custody hearing. What do I do? I asked. You respond with documentation, she said. Every pharmacy record, every doctor's visit, every communication where you coordinated his care. We bury this motion in paper. So that's what we did. I pulled 2 years of pharmacy records showing every prescription refill, on time, always with days to spare. I got a letter from Owen's pulmonologist, Dr. Anand Murthy, stating that Owen's asthma was exceptionally well managed and that the father had been the primary point of contact for all medical decisions. I compiled every email and text I'd ever sent about scheduling doctor's appointments, picking up medication, checking in after school on high pollen days. We filed our response. Patricia called it one of the most thoroughly documented rebuttals she'd submitted in years. The judge didn't rule immediately on the motion. It stayed open, hanging over the case. 6 weeks before our scheduled custody hearing, something shifted. Owen came back from a weekend at his mother's house quieter than usual. He was 9 by this point, old enough to sense tension but young enough that it still came out sideways, in behavior rather than words. He was irritable at dinner, short with me. When I asked if everything was okay, he said yes and went to his room. I didn't push. I've always believed in giving him space to process and come to me when he's ready. He came to me that night, about an hour after I'd put him to bed. He knocked on my bedroom door, something he rarely does, and came in and sat on the edge of my bed. "Dad," he said, "is our house going to change?" I asked him what he meant. He said, "Mom says I might be living with her most of the time. She said it's because you're not good at taking care of me when I'm sick." I kept my voice very steady. I told him that wasn't true, that I always made sure he had his medicine, that his doctor had even written a letter about how healthy he was. He nodded slowly. Then he said something that I didn't fully understand until weeks later. He said, "I don't think it's fair what she's doing, Dad. I see what happens." I asked him what he meant. He looked at the floor for a moment. Then he looked up at me and said, "When she thinks I'm asleep, she's not asleep." I didn't ask any follow-up questions that night. I hugged him, told him I loved him, told him I was handling everything, and got him back to bed. But I lay awake for hours thinking about what he'd said. The following week, I had a scheduled call with Patricia. I mentioned Owen's comment almost in passing. I wasn't sure it was relevant. Patricia went quiet for a moment. "Daniel," she said carefully, "has Owen ever expressed that he's witnessed behavior at his mother's home that concerned him?" I said not explicitly, but that his comments suggested he was aware of something. She said, "He's 9 years old. He can't testify. But if he's seeing things that are relevant to the custody determination, things that speak to her fitness as a primary custodial parent, we may want to explore how that information can be brought into the record." I asked what that meant. She explained the concept of a guardian ad litem, a court-appointed advocate assigned specifically to represent the child's best interests, separate from either parent's attorney. She said in cases where a child may have material information, a guardian ad litem could interview the child and potentially relay or support testimony. She also mentioned something else. Depending on his age and the judge's discretion, a child could, in some cases, testify directly, particularly if the child was mature, clearly willing, and the testimony was relevant. Owen would turn 10 before our hearing. I told Patricia I wasn't going to put my son in the middle of this. I meant it, but I also told her to keep all options open. In the month before the hearing, I did 2 things that mattered. The first was personal. I sat down with Owen, calmly, not urgently, and told him that some adults would probably be asking him some questions about his life, about how he felt, about where he liked to spend time. I told him the most important thing he could do was tell the truth, always, no matter what. I did not tell him what to say. I did not ask him to repeat his comment about nighttime. I just told him the truth was the only thing that mattered. He looked at me and said, "I know, Dad. I'm not going to lie." The second thing I did was more deliberate. My attorney had filed a request for a guardian ad litem. The court approved it and assigned a woman named Carol Hendricks, a licensed social worker with 12 years of family court experience. She met with Owen twice. She visited both homes. She interviewed me, interviewed Yvonne, interviewed Owen's teacher, and spoke briefly with Dr. Murthy. I did not coach Owen before his meetings with Carol. I told him she was a nice person whose job was to make sure he was okay and that he should just be himself. What Carol discovered, what she documented in her report, was not something I had told Owen to say. The hearing arrived on a Thursday morning in March. The courthouse was a mid-sized county building, the family court division on the third floor. I wore a gray suit, conservative, professional. Patricia had advised me to look exactly like what I was, a stable, employed, responsible father. Yvonne's attorney, a man named Barrett Coles, opened with a presentation that